Yeah.
Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution, ADR, in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, the Marketing Liaison of Ombuds Day 2024 American Bar Association Dispute Resolution and the host of Expert Views on ADR Ever video podcast show. I'm delighted to welcome Hon.Justice Nelson Ogbuanya to the Ever show. He is a judge of the National Industrial Court of Nigeria. Before his appointment as a judge, he was a senior lecturer and head of Department of Corporate Law Practice at the Nigerian Law School, and the author of the Council of Legal Education approved textbook, Essentials of Corporate Law Practice in Nigeria. He wears many hats, so I've left the link to his profile. Welcome to the show, sir. Let me stop sharing my screen now.
Thank you very much, Chinwe.
Thank you. Such an honor to have you. So without further ado, the first question is, what is ADR and does it advance and does it present a suitable mechanism in advancing workplace conflict in Nigeria?
Yeah. I have this view I share also with you by trying to look at ADR not from alternative perspective,
yes,
but actually appropriate.
Yes.
In fact, in one of my judgments, I wrote clearly that it is actually appropriate dispute resolution. Because in Africa here, the ADR, as it were, was actually the traditional, the original, the first instance justice system.
Yes.
It was not actually meant to be alternative as it's so described now, borrowing from the Western system. So to me, if I've been a product of the systems, both the traditional system now and the Western cultured justice system, which we are practicing. So from the local traditional perspective, it is appropriate. It is indigenous. It is the first model that we were brought up with. So in a traditional African setting, you see going to court as that you have no other option. It's like you even failed the people that you are reporting them to the court. Even now in most societies, that is what is practiced in Africa across board. So that's why when you are talking about ADR from the perspective of alternative in Africa, somehow we are not very comfortable with that, because it is the first system we met before we now grow into the system of westernized system and then got the court system, and then suddenly in the court system you are now seeing the one you are really born into as alternative. So conceptually that's an issue with that, but be that as it may, we have seen ADR as a thriving model of dispute resolution. So it is neither alternative in the way it is being conceived, nor is it a second-class model of dispute resolution has also been conceived. So these are the misconceptions of ADR in African perspective. So for me, if you want to talk about ADR, look at it from the appropriate dispute resolution model. Conceptual, psychologically satisfied, win-win approach, having to be able to be participatory in nature, not even necessarily getting a third-party expert to help you to solve your problem, but merely to guide you to bring out that your view. If, for instance, we look at negotiation as a model of ADR, negotiation is linear. Two sides of the pole, one side here, the other side here. One of the challenges of negotiation is that people are, find it difficult to communicate with themselves directly. So when people are in dispute, the first problem they have is communication. So as communication becomes a sign of dispute, So negotiation is finding it difficult to find a stay in dispute resolution because parties are already having problem with communication. Therefore, starting themselves in a linear pole where one stands here and another stands there to talk together without a third party interference is always a problem in negotiation. Now, if you move it a bit and see where did mediation come in? Mediation comes in to create the third leg, in a tripod system where a third party neutral that understands the parties' issues, that will be able to command the respect, of the parties in dispute comes into play. And that's why mediation, carries its sagacious play in this position in the modern dispute resolution, that the person that is coming in is seen as somebody who understands the dynamics of the dispute. You also see him as somebody who is capable of resolving it to their satisfaction without showing any bias, because he's not actually taking a decision, but guides the parties into the dispute area, understands the underlying dispute, and then comes into a way of giving them an environment to discuss. So mediation subsumes negotiation in that circumstance, that actually parties are still negotiating, but that they cannot do this alone on themselves, by themselves. And that's the beauty of mediation. And if you look at the other models like arbitration, people begin to ask, is arbitration actually ADR? Is it really ADR? And then there are a lot of schools of thought that come into that concept. To me, I say, look, what do you really want to achieve? And that's where appropriate dispute resolution comes in. For instance, to accommodate arbitration. Because it is not truly an ADR concept. Because it is setting up an alternative court system, a private court kind of, a court that all the legalistic approaches are done in arbitration, and decision taking model for that matter, which is similar to litigation. So arbitrators are supposed to take a decision that's enforceable and put into the people to accept as binding decision. So with that, you see arbitration. But then, because parties chose it, because parties are participating and decide to be part of it, then it becomes psychologically satisfying, other than imposed system where you go. Though some aspects of arbitration share these characteristics of imposed decision maker, like institutional arbitration. So in all this, the idea is to have parties participate, have an input in disputes that involve them. That is the idea. And which one should be most appropriate that will allow parties to actually take full control and participate and take ownership of the outcome. That is why ADR comes into play. So if you look at it from that perspective with your question as to suitability of ADR and workplace dispute. Yes, just recently, one of our colleagues in the court did a decision that Mediation and Arbitration and Mediation Act of 2023 is not applicable to labor dispute. Yes. The argument is that labor is not a commodity, and therefore you cannot commercialize human discussions or discussions involving humans, because already we have abolished slave trade. In other words, if you allow people to take it as commercial dispute, as it were, in the Mediation, Arbitration and Mediation Act, which actually talk about commercial arbitration, then you are exposing humans to commodity level. To that extent, that is correct. But then, the ADR as a concerns workplace, a lot of issues arising at workplace are clearly disposed for resolution at the ADR level. I've had several examples of it. Just not quite long ago, I had a matter involving a forcefully retired officer And most of the dispute they had were about approvals and use of money in the office and so many issues that are almost petty. Not that they wanted to get the man out. So, but the man is in custody of several issues that if you take him the way he want to present his case, is likely to ruin the entire personality of all the people involved in the office. I said, this is one of such matters that ADR is best suitable to resolve. Because the man is not even saying, I want to go back to office. He's saying, look, if you want me out, pay me all that I'm entitled to. If you don't do that and just take me out that because you have fiat power to do so, then I'll be in court and I'm going to say a lot that happens here. And by that time he spills the bean, of course, you know that it will ridicule the entire brand of the organization on how they do things. Not that anybody is trying to cover them up, but that using the forum of court environment to raise some uninvestigated issues, even when you turn out letter to say you want to investigate those things, all of that things are already in public domain.
It's true.
Even if it turns out to be false, then how many people are you going to be convinced that these things are not the way they were presented in court? So that I said, look, gentlemen, I'm also part of the ADR, and the ADR is also part of our court. This is our court, the National Industrial Court, is the only court in Nigeria that has a statutory authority to set up a center of ADR center, right from the Constitution. So the provision of the Constitution is very clear, saying that we should set up ADR center, and the ADR center should be in charge of such things using mediation and other hybrid processes. So the instrument of office was created, and the centers were built across board, and officers were appointed. So carrying out that constitutional mandate, then why would we say that workplace dispute is not disposed to ADR? Whereas the Constitution already said so. Administratively, those centers have been set up, and the courts are now referring matters to ADR, and then at the end of the day, they return back to the court, and then you use the authority of the court to enforce it. So it is idle for somebody to be thinking that ADR is not amenable to workplace disputes. It is very much amenable to workplace dispute in Nigeria. The problem is how to contextualize it and actually carry it out within the framework of the law. That is just the issue. So if people fail to understand how to carry it out in practice, that does not mean it's not amenable. Legally speaking, it is.
Thank you so very much, my lord. I was about asking how many employees are aware that they can settle via ADR in Nigeria. But let me go back to what you highlighted about mediation act. I want you, if it's possible for you to expand on the new mediation act, because initially it wasn't formalized in Nigeria up until I think in 2023. Can you expand on that, please?
The mediation, the already existing act, the 1988 Act, which was the Mediation and Arbitration and Conciliation Act, was actually abolished by the new law, which replaced conciliation with mediation. That's a major milestone from name perspective. The other one was called Arbitration and Conciliation Act. This new one is now Arbitration and Mediation Act. So thereby bringing mediation in the form of dispute resolution. So that is to show that mediation is a recognized and a statutorily empowered model of dispute resolution in Nigeria as of today, courtesy of the Arbitration and Mediation Act 2023. So the law was meant to create a made-up approach, a model approach of a hybrid, that if you want to go to arbitration, you can also go to mediation. Settlement arriving from the mediation processes are now enforceable as against the period, it was as if it was a gentleman's agreement, where you just do it and then you don't have the real framework to rely on to say that we have conducted mediation. So as of today in Nigeria, you can now conduct a mediation proceedings and get it enforced as a judgment of a court and get it enforced as an arbitral award. So it's sharing the same level of authority with a litigation arising from judgment of court and an award which is coming from arbitration. So mediation settlement agreements are also now recognized as a lawfully, legally empowered system of dispute resolution. That's what he has done. A milestone ahead to recognize and integrate mediation into the tripod of the dispute resolution models.
Thank you so very much for that. My lord, so can we go back to what extent our employees are aware that they can utilize ADR to settle workplace disputes, especially when there is a conflict pertaining to discrimination, bullying, and harassment at their workplace?
Yeah, I think is beyond the issue of awareness.
Yes, sir.
I think we need to tinker with the position of the law, as it were.
Yes, sir.
What we have in our ADR center rules is a dispute existing in court.
Yes, sir.
Therefore, when you are in court, you can be referred to ADR center. It was not actually court connected in the system of where you can have a walk-in. So as of today, we don't have a walk-in system.
Yes.
So that walk-in system is where you can discuss somewhere else, come in and file what we have done, and then get it enforced. So the first channel here is file a suit in court. If your case is amenable to arbitration, mediation or ADR, it will be referred there. Now, there is institutional psychological defect in work-related disputes.
Yes, ma'am.
Because you will be seen from suing your employer, you'll be seen as a cantankerous person, you'll be seen as a non-tolerant person, you'll be seen as a stubborn person, so to say. And then your appraisers are there, and then this is the intricacies of dispute resolution emerging from labor and workplace disputes. The resolution is actually very difficult because that's why people to mark a lot of issues, because if you do so, then they say you are stubborn. You've taken that to court. So then, and the HR departments of many organizations are also very weak, because those HR situation departments are the zones left for originating and initiating such steps. For instance, if there is a sexual harassment in an office,
Yes, sir.
what the victim simply needed to do is to refer the matter to the HR in confidence. The HR will now initiate these proceedings. Even if it requires the HR to take up a legal action, as it were now, against existing boss in office, they will be able to do so.
Yeah.
Actually, what the original conception of legal department and human resource department was to create an independent body, more or less within a system that creates a kind of strong corporate governance. Speaking from corporate law now, I get it. So if you see that the structure is in place and which you should be advocating, that even when you are in office, the HR should be a custodian of the governance structure of the organizations in terms of ethical rules and regulations and compliances. So they will not just be seen as a small unit that is there. Because if somebody just go out on his own or her own to quickly file a case directly against an organization while he's inside, the perception is that the person is stubborn, unless it has escalated to a very high level.
Yes,
but
sir.
why do you want not to take a small claim? Why do you want it to become so escalated before it gets to court or anything, or become big? If a character is bad, it should be controlled from the beginning. It should be nipped from the bud. That means the HR department should be very effective, so that if this type of issue comes up, The victim will just have to report. If the HR feels that the person is so powerful that he will stop proceedings within, now we will bring it to court. And he brings it to court on behalf of that employee that is victimized. Are you getting it?
Yeah.
Then the court can also, these things may not even be discussed fully in open court. Let us preserve the image of people because we are trying to protect the system also from what is wrong. Are you getting it? So rather than propagating it, naming and shaming, but stop this person from behaving like this, or give him a soft landing outside the system because of this character that is in. Because you see, some of what the organizations are afraid of, you know, from corporate law point of view, is corporate branding.
Yes, sir.
You have this type of staff in your organization. So when the scandal blows up, the organization is no longer seeing it from the person that committed the offense or did the wrong thing, but seeing it from the perspective of the victim, that the victim has exposed the organization to ridicule. So these are the intricacies of workplace issues. So if the HR is working effectively, they could be the ones in charge of such things, because you still want to maintain your corporate brand, but will not tolerate certain behaviors in workplace. So a hybrid system could be, HR should report, take over such matters. Once there's an infringement or such issues, HR will be informed. HR will quickly, be able to discuss that issue, yes, and be able to set up an ADR system to even compensate that victim, rather than shaming the victim and humiliating the victim, and the victim be seen also as a stubborn person, seen as a person who don't want to expose the organization to ridicule in the public domain. So that's where the awareness is having a problem. So it's not that people are not aware, but how to carry out the awareness is where I'm addressing from. So awareness is not really the problem. Awareness is there. A lot of people are on the network, they read, they write, they are aware of many things happening in the society. The literacy level is high, but the capacity to carry out literacy issues is what is low. So it's not about that you are not aware, but you are worried about the outcome of what you are carrying out, what you are aware of. So a mechanism should be on ground where you will see immediately. If, for instance, you say, okay, if there is, let me give you an example of I did in one case one time, and I had to go out of my way to analyze the victims of whistleblowing in workplace. Yes. In this particular case, a lady reported her boss. She not reporting as a complaint, just that she was invited in a panel where her boss was involved in an issue. The boss ordinarily expected her to protect her, but she went out to say things that was happening in their unit, and then the lady was suspended. After the lady returned back to office, then he took her on to the extent that she lost her job. So look at that scenario. She will not tell her child to report any issue in office as a matter of whistleblowing or whatever. So even when the organization had set up whistleblowing policies, yet the challenge in workplace is very high. Because again, the law is protecting the weak. It's not that it is wrongly presented in law. The question is, if you allow it to be this way without such strict mechanism, what of innocent ones that will just be blackmailed? Nobody will not wake up one day and say, this is what they are happening in workplace. There's a workplace politics. It's beyond the Nigerian politics of the PDP APC. When you go to workplaces and see the corporate structure and the politicking, then you will agree with me that it's possible that people can frame up somebody even when he did not do anything wrong.
It's true.
So the mechanism was to make it strict. But while making it strict, we need to have a situation where the dispute resolution aspect of it should be handy, right from the office to the courtroom. I get it. So if the court recognizes such working situations that we are not coming here for any dispute, We are coming here that there's an issue in the office, and this is what we want. Give us a forum, a place where we can use the court system to address it. And from that, we go. I get it. That will give it a higher teeth than the HR is talking in the office. Perhaps the boss is the one involved, and this and that. So if it's a referral, so that's one of the advocate, and one can be advocating that ADR centers at the National Industrial Court should also have a walk-in program where certain matters can come without filing a formal suit, so that it will not remove the psychology that you have sued us.
I thought we have a working center with the multi-door courthouse.
Yeah, that is multi-door court has that in the state high courts.
Yes, sir.
I get it. But under the ADR center instrument and law, there was no provision for working.
For working, yeah, you're right. Okay. Thank you, sir.
I get it. So they have the reasons for putting it that way, but I was expecting that there would be an exception, a special case like this type of scenario involving confidentialities and private issues, and involving situation where the outcome will look like somebody is being, suing the organization.
Thank you so very much for highlighting that. I also wanted to touch on the fact that the trade unions, I had when I conducted interview last year, that they are not generally in support of the ADR settlement. I don't know how true that is.
I really didn't see it from that perspective, but seeing it that ADR is not being perceived as a genuine, truthful discussion.
Yes, sir.
So what they usually do in the so-called ADR is maybe on the side of the union don't trust their leaders. They think they have gone there to compromise, and they just say, oh, no, these people, they are representing themselves. And on the part of the government, the members will also see that the government just came to intimidate them and just hand them over something in a standard contract format.
Yes.
So I think the problem is suspicion. This problem is suspicion, more of suspicion that, they don't trust what has happened in that kind of ADR. And therefore they don't trust ADR. I get it. So as against their formalized system, which is clearly spelled out at the Trade Dispute Act. But the problem is that the Trade Dispute Act is also due for review. I get it. The Trade Dispute Act is completely out and out of date, and therefore is not addressing the yearnings of today in terms of enforcement of decision, or actually taking ownership of decision, or even activating it. Activation of ADR mechanism is not done in a normal ADR processes when it comes to trade dispute. If you look at the Trade Dispute Act, the provision is actually something different from what we have in normal ADR practice. Therefore, the system appears not to be user-friendly.
Yes, sir.
Sir, can I interrupt you there? There's this thing about the Minister of Trade and Industry having so much power that parties cannot submit their grievances directly to the arbitral body without consulting. So
exactly, even the award is not published to parties. Awards are published. So I did a paper as a 2004, a very long time ago. I think I published in one of these books. The top title of the paper is arbitration in the trade dispute. How it is applicable in trade dispute. Whether arbitration is actually suitable and what made it unsuitable.
Yes.
I get it. Yes. It was one of good work I did those days. So in that argument, pointed out that the whole thing happening here is not exactly what we know in arbitration. what we know in arbitration is the consensual, the ability to even initiate or serve notice of arbitration, the ability to participate by appointment of arbitrators, the ability to participate in the proceedings without you being a weak party. At the end of the day, having a right to receive an award and review and it. All these essentials of arbitration were lacking in trade dispute aspects of it. So to that extent, you cannot see it from the perspective of normal arbitration as we know it. So when you go to industrial arbitration panel, it is not aggrieved parties that initiate dispute. Neither do they get published award. So the idea of arbitration as a model is not there. And then there's no, the other models were used as stepping stones. It's not autonomous model. You know, it's an advanced argument now. If you look at the Trade Disputes Act provisions for mediation and ADR, the mediation procedure there is not a terminal process. It's a stepping stone to something. Yes, you have to pass through it to get to the other side.
Yes, sir.
Because the mediation that is there is not actually designed to end the dispute, in my view. It was designed as a step towards ending the dispute. So there is no separate ADR standing alone, start and stop on a dispute. So rather is saying, if you go through this, you go through that. Already we know the challenges of conciliation. Today is even doubtful which law now sustains conciliation in Nigeria, where conciliation has been abolished in the Arbitration Act. So the only conciliation lingering in Nigerian legal system is the one still contained in the Trade Dispute Act. So consider why the Arbitration Act has dealt with that part and removed the conciliation. It is still being retained in the Trade Dispute Act. So that part is a clog, because conciliation is not useful and is not effective model of dispute resolution, and worldwide it's been abolished.
Yeah, but you know, some people argue that it's the same with mediation, so maybe that's why it's not specifically.
It can be because the aspects of mediation that conciliation is confusing is when you come to decision-making level.
Yes,
in conciliation, actually decisions are being made and now being presented for parties. Are you getting it? And in conciliation, where a decision actually had been made, look at the way conciliation operates, like a customary mediation in the village system.
Yeah.
In the village system of customary mediation, the elders will sit and keep a body language and then suggest to you what they think is their position. And then when you disagree or not going through their level, they flare up. When they flare up, the next thing is that you are stubborn, and therefore a new dispute will arise from the original one. And nobody's talking about the original dispute, but that you despise them. They were trying to encourage you. They won't try to do this, and then you are not even yielding. So you could see that model featuring in conciliation.
Okay.
The moment a body language, either expressly or covertly or overtly, comes out that this is what these people want as a position on this matter, which is an essential aspect of conciliation. Once that is out, yeah, it is in conciliation, we are not bound to accept it. Yeah. But then the psychology of it, where do you place it? Unlike mediation, where you don't need to suggest at all. Are you getting it?
Yes, sir.
You just need the parties to facilitate to arrive. You are guiding. You don't give them a decision. Are you getting it?
Yes, sir.
In arbitration, you give a decision.
It's true.
In court decisions, litigation, you give a decision. So, where does conciliation lie in these two models? A model of no give decision, in a model of give decision. it is now presenting itself as I suggest decision that is I cannot even give you.
Thank you so much, sir. We've got 1 minute. Thank you so very much. It has been a masterclass. Thank you so very much for coming on the show. Thank you, my lord.
Yes.
Bye.